Executive clemency. What is the nature and limitations of executive clemency? Section 19, Article 7, except in cases of impeachment or as otherwise provided in the Constitution, the President may grant reprieves, commutations, and pardons, and remit fines and forfeitures after conviction by final judgment. General exceptions to executive clemencies. 1. In case of impeachment, so dili pwede. And 2. As otherwise provided in its Constitution. Example, for election offenses. No pardon, amnesty, parole, or suspension of sentence for violation of election laws, rules, or regulations shall be granted by the President without a favorable recommendation by the Commission on Election. Section 5, Article 9. 3. In case of legislative and civil contempt. 4. Before conviction by final judgment, except amnesty. And 5. Without concurrence of majority of all members of the Congress in case of amnesty. Section 5, Article 9. What are the forms of executive clemency? 1. Reprieve. 2. Commutations. 3. Amnesty. 4. Remit fines and forfeitures after conviction by final judgment. 5. Pardon. 6. Parole. Yeah, I think that's it. Okay, let's define executive clemency forms. Number 1 is reprieve. A temporary relief from or postponement of execution of criminal penalty or sentence or a stay of execution from Black's Law Dictionary. It is withholding of a sentence or an interval of time, a postponement of execution, a temporary suspension of execution from the case of People v. Vera, 1937. Next, commutations. Commutation is reduction of sentence. It is a remission of a part of the punishment, a substitution of a lesser penalty for the one originally imposed. Still from the same case. Third, amnesty. Amnesty is a sovereign act of oblivion of past acts, granted by the government generally to a class of persons who have been guilty usually of political offenses and who are subject to trial but have not yet been convicted and often conditioned upon their return to obedience and duty within a prescribed time. From the case of Brown v. Walker, 161 U.S. 602. Amnesty requires concurrence of the majority of all members of Congress under Section 19, Article 7. 4. Fines. Remit fines and forfeitures after conviction by final judgment. 5. Pardons. Pardon is a permanent cancellation of sentence. It is an act of grace proceeding from the power entrusted with the execution of laws, which exempts the individual on whom it is bestowed from the punishment the law inflicts for the crime he has committed. It is a remission of a guilt, a forgiveness of the offense. 6. Parole. Parole is a suspension of the sentence of a convict granted by the parole board after serving the minimum term of the indeterminate sentence penalty, without granting a pardon, prescribing the terms upon which the sentence shall be suspended. Pardon. Pardon could either be plenary or partial. Plenary pardon extinguishes all penalties imposed upon the offender, including accessory disabilities. Wow. Ang partial pardon does not extinguish all penalty imposed. Pardon could also be conditional or absolute. Conditional pardon, it is where the offender has the right to reject the same since he may feel that the condition imposed is more onerous than the penalty sought to be remitted. The determination of whether the conditions have been breached rests exclusively in the sound judgment of the chief executive. From the case of Torres v. Gonzalez, 1987. Absolute pardon is where the pardonee has no option at all and must accept it whenever he likes it or not. In this sense, an absolute pardon is similar to commutation, which is also not subject to acceptance by the offender. What are the limitations of pardon? Kano sa man di magamit ang pardon? 1. It cannot be granted for impeachment. Section 19, Article 7. 2. cannot be granted in case of violation of election laws without the favorable recommendation of COMELEC. Section 5, Article 9C. 3. It can be granted only after conviction by final judgment. From the case of People versus Salye, 1995. Section 19, Article 7, prohibits the grant of pardon, whether full or conditional, to an accused during the pendency of his appeal from his conviction by the trial court. Any application, therefore, should not be acted upon, or the process towards its grant should not be begun unless the appeal is withdrawn. Fourth limitation on pardon. It cannot absolve the convict of civil liability. From the case of People versus Nacional, 1995. 5. Cannot be granted to cases of legislative contempt or civil contempt. 6. Cannot restore the public offices forfeited, even if pardon restores the eligibility for said office. From the case of Monsanto versus Factoran, 1989. However, if pardon is given because he did not commit the crime, reinstatement and back wages should be or would be due. The case of Garcia versus Coa, 1993. The right to seek public elective office is unequivocally considered as a political right. Hence, upon acceptance of the pardon, the pardonee regained his full civil and political rights, including the right to seek elective office, even though that right is not expressly mentioned as provided under Article 36 of the revised Penal Code. From the case of Rasus Vidal versus Comelec, 2015. What are the difference between pardon and amnesty? Pardon refers to applies to infractions of peace of the state. Ang amnesty is addressed to political offenses. Pardon is granted to individuals, while amnesty is granted to classes of persons. Pardon, exercised solely by the executive. Amnesty requires concurrence of Congress. Pardon is a private act which must be pleaded and proved. Amnesty is a public act which the courts could not take judicial notice. Pardon looks forward and relieves the pardonee of the consequences of the offense, while amnesty looks back and puts in oblivion the offense itself. Sana all amnesty. Pardon is extended after final judgment. Amnesty may be extended at any stage. Differentiated from probation. Ano siya ang kalainan sa pardon and probation? What's the difference between pardon and probation? Probation is the disposition where a defendant after conviction and sentence is released subject to 1. Conditions imposed by the court, and 2. Supervision of a probation officer from PD number 968, section 3A. How is it different from parole? How is pardon different from parole? Parole is the suspension of the sentence of the convict granted by the parole board after serving the minimum term of the indeterminate sentence penalty. Kung papriso sa ka before ka maparole, ang pardon kay waits without granting a pardon, prescribing the terms upon which the sentence shall be suspended. Application of pardoning powers to admin cases. 1. If the President can grant reprieves, commutations on pardons, and limit fines and forfeitures in criminal cases, with much more reason can she grant executive clemency in administrative cases, which are clearly less serious than criminal offenses. Makes sense. 2. However, the power of the President to grant executive clemency in administrative cases refers only to administrative cases in the executive branch. From Llamas versus Executive Secretary, 1991. Denial of commission of offenses. Persons invoking the benefit of amnesty must first admit to their complicity in the crimes charged. Amnesty presupposes the commission of a crime. And when the accused maintains that he has not committed a crime, he cannot have any use for amnesty. The case of Vera versus People, 1963. Amnesty. Who may avail amnesty? Generally, individuals for whom or who from part of the class of persons covered by an amnesty proclamation whose acts constitute political offenses covered by the same. Amnesty Proclamation number 76 applies when hukbalhaps already undergoing sentence upon the date of its promulgation. The majority of the court believes that by its context and pervading spirit, the proclamation exists to all members of the hukbalhaps. Tolentino versus Catoy, 1948. The Supreme Court agreed with the Sandigan Bayan that, in fact, the petitioners were expressly disqualified from amnesty. The acts for which they were convicted were ordinary crimes without any political complexion and consisting only of diversion of public funds to private profit. The Amnesty Proclamation covered only acts in the furtherance of resistance to duly constituted authorities of the Republic and applies only to members of the Moro National Liberation Front or the anti-government groups, from the case of Makagaan versus People, 1987. Okay, let's go to the next. Executive power. Diplomatic power. The fuck are you reading, Bell? Diplomatic power. What is the scope of diplomatic power? The president, being the head of the state, is regarded as the sole organ or authority in external relations and is the country's sole representative with foreign nations. As the chief architect of foreign policy, the president acts as the country's mouthpiece with respect to international affairs. The president is vested with the authority to 1. Deal with foreign states and governments. 2. Extend or withhold recognition. 3. Maintain diplomatic relations. D. Enter into treaties. And E. Transact the business of foreign relations. From the case of Pimentel versus Executive Secretary, 2005. Treaty-making power. What is a treaty? As defined by the Vienna Convention on the Law of Treaties, it is an international instrument concluded between states in written form and governed by international law, which embodies in a single instrument or in two or more related instruments and whatever its particular designation. Bayan versus Executive Secretary, 2000. Note that it is the President who ratifies the treaty and not the Senate. The Senate merely concurs, from the case of Bayan versus Executive Secretary. Thus, the President cannot be compelled to submit a treaty to the Senate for concurrence. He has the sole power to submit to the Senate and or ratify it. The case of Bayan Muna versus Romulo, 2011. Military Bases Treaty. Section 25, Article 18. After the expiration in 1999 of the agreement between the Philippines and the United States of America concerning military bases, foreign military bases, troops, or facilities shall not be allowed in the Philippines except under a treaty duly concurred in by the Senate and, when the Congress so requires, ratified by a majority of the votes cast by the people in a national referendum held for that purpose and recognized as a treaty by the other contracting state. The President, however, may enter into executive agreement on foreign military bases, troops, or facilities if 1. It is not the instrument that allows the presence of foreign military bases, troops, or facilities, or 2. It merely aims to implement an existing law or treaty. Section 25 of Article 18, Morning Military Bases Treaty, refers solely to the initial entry of the foreign military bases, troops, or facilities. To determine whether a military base or facility in the Philippines, which houses or is assessed by foreign military troops, is foreign or remains a Philippine military base or facility, the legal standards are A. Independence from foreign control, B. Sovereignty and application of law, and C. National security and territorial integrity, from the case of Sagisag versus Executive Secretary, 2016. Visiting Forces Agreement. The VFA is the instrument arranged upon to provide for the joint Republic of the Philippines U.S. military exercise Exercises is simply an implementing agreement to the main RP-US Military Defense Treaty. The VFA is therefore valid, for it is a presence allowed under the RP-US Mutual Defense Treaty. Since the RP-US Mutual Defense Treaty itself has been ratified and concurred in by both the Philippine Senate and the U.S. Senate, there is no violation of the constitutional provision resulting from such presence. The case of Nicolas versus Romulo, 2009. Executive agreements. Ano man ang executive agreements? A. Entered into by the President. B. May be entered into without the concurrence of the Senate. C. Distinguished from treaties. International agreements involving political issues or changes in national policy, and those involving international agreements of permanent character usually take the form of treaties. But international agreements involving adjustments in detail, carrying out well-established national policies or traditions, and those involving a more or less temporary character usually take the form of executive agreements. From the case of Commissioner of Customs versus Eastern Sea Trading, 1961. Yeah, let's just finish this. Note. However, from the point of view of international law, there is no difference between treaties and executive agreements in their binding effect upon the states concerned, as long as the negotiating functions or functionaries have remained within their powers. USAF Veterans versus Treasurer, 1959. Note, an executive agreement that does not require the concurrence of the Senate for its ratification may not be used to amend a treaty that, under the Constitution, is the product of the ratifying acts of the executive and the Senate. The case of Bain Muna versus Romulo. What are the two classes of executive agreements? 1. Agreements made purely as executive acts affecting external relations and independent of or without legislative authorization, which may be termed as presidential agreements. And 2. Agreements agreed into in pursuance of acts of the Congress or congressional executive agreements. Although the President may, under the American constitutional system, enter into executive agreement without previous legislative authority, he may, by executive agreement, enter into a transaction which is prohibited by statutes enacted prior thereto. He may not defeat legislative enactments that have acquired the status of law by indirectly repealing the same through an executive agreement providing for the performance of the very act prohibited by said laws. The case of Gonzales versus Hetchanova, 1963. Deportation of undesirable aliens. The President may deport only according to the grounds enumerated by law, otherwise it would be unreasonable and undemocratic. The case of Quachegan versus Deportation Board, 1963. What are the two ways of deportation of an undesirable alien? 1. By order of the President after due investigation, Chapter 3, Book 3 of the Admin Code, 1987. 2. By order of the Commissioner of Immigration under Section 37 of the Immigration Law, from the case of Quachegan versus Deportation Board. Scope of power to deport. 1. The presidential power to deport aliens and to investigate them subject to deportation are provided in Chapter 3, Book 3 of the Admin Code, 1987. 2. There is no legal or constitutional provision defining the power to deport aliens, because intention of the law is to grant the chief executive the full discretion to determine whether an alien's residence in the country is so undesirable so as to affect the security, welfare, and interests of the state. And 3. The chief executive is the sole and exclusive judge of the existence of facts which would warrant the deportation of aliens. From the case of Gotek versus Deportation Board, 1977.